And on this Tuesday morning, as I indicated, it is our Tuesday morning law talk with any number of the lawyers from FH&P. And Nancy Ling joins us in studio this morning. Ms. Ling, good day to you.
Good morning.
You indicated it's a crazy busy time right now.
It's been pretty busy, yeah.
Driven in part by budget and nobody knowing for sure what might be, could be, would be in the budget.
Right. There are some rumors about capital gains that got some people in a tizzy.
And suddenly it's, I need some time. we got to talk.
And it just ended up being a rumor. Nothing came from it.
Isn't that amazing what rumors cause people to do?
Right.
So take me by the hand. Where are we going to go today on
I wanted
this morning?
to talk a little bit about family under, an estate planning context. We've talked about it a little bit before, but we always seem to focus on spouses and, blended families, things like that. So I wanted to go over it a little bit again, but also bring up children as well, who qualifies as a child if we're talking in estate planning or wills variation.
And in a time of mixed marriage, in the time of second and third and fourth marriages, who constitutes a child and what's their relationship to the individual becomes an exceedingly complex equation.
Right. So there's kind of three reasons I want to look at this. We tend to make our own families these days. It's not the same nuclear family that it used to be back in the 60s.
Isn't
right?
that the truth?
Right. So we've got mixed families. We've got same-sex relationships. We've got stepchildren. We've got assisted reproduction. We've got all sorts of different ways to put together a family. And if you do an estate plan and do a will, you can define who your own family is. If you don't, however, the law defines who are your children, who is your spouse, things like that. And also, who your children are and who your spouse are applies if you're wondering who can attack your estate plan. So, for wills variation, for who inherits if you don't have a will, and if you leave a will and say, I leave everything to my children, then who falls in that definition of children?
Right. Take me then, and I'll follow you. A couple of weeks ago, we were in conversation with Colin Flanagan, and in the course of that conversation, we ended up to a degree driven in part by myself because my mother had left a will, but she'd been advised by the lawyers who were writing the will for her, who were assisting her. There's a black sheep child in our family, and it was her natural inclination to leave them out. Mm-hmm. And it was suggested that, no, that would be a mistake. Instead, you need to determine what you want to do and make sure that those provisions are written into the will, because if you put him into the will, in spite of what kind of a relationship may have existed, effectively what you've done is you've made a bequeath, you've justified the bequeath, and therefore you've, to a great degree, you've prevented him from taking action.
I think you guys did talk about this last time.
Yeah.
That's not necessarily
the context that we're going to today.
Yeah, but it's all going to look in the facts of each individual scenario. So what was the specific relationship, and was there some reason for you to have disinherited them, things like that. So it doesn't matter if you leave them the wooden nickel or $1 or whatever. That doesn't give you a full defense.
Yeah, okay.
But here,
So where's our starting point?
Well, I'll talk briefly about spouses, but I do want to focus on children because we haven't really talked about that before.
Okay.
So spouses, people get confused because there's different treatment for different reasons, right? And there's all sorts of rumors out there. You can become a common law spouse as soon as you move in, things like that. But in BC, and it is unfortunately different across the different provinces, but in BC, for estate planning purposes, so for someone's ability to inherit if you die, you're a spouse if you've lived in a marriage-like relationship for 2 years. So if you're married or you've lived in a marriage-like relationship for 2 years. For family law, if you're going to get divorced, if you're going to split up the assets and you're both alive, it's a little bit different. It's that 2 years, or if you have a child. Mm-hmm. So it can be earlier than 2 years if you guys have a child together. And then for income tax purposes and GST credits and old age security and things like that, it's 1 year. So there's different reasons why someone might become a spouse, but under estate planning, it's 2 years living together in a marriage-like relationship. And then once you separate, whether you're married or common law, the instant you separate, you're no longer spouses. So it doesn't matter if you've been together for 2 years or 43 years. Once you separate, you no longer get to inherit if they die as a spouse. So
Okay.
that's fairly straightforward.
Yeah, those are simple rules.
Right.
Those are the cut and drieds that have been around since men and women were having relationships and dying and preparing wills.
It gets a little bit complicated when people litigate because you have to try and prove when people started living together. You have to try and prove whether or not they separated, whether or not they reconciled, things like that. That's not always clear cut, especially if you're fighting against the other family members who are looking to inherit. They're going to have evidence saying that you guys had separated, and you're going to try and claim that no, you just went away for the weekend to blow off some steam.
That's when it gets into the fractious, convoluted. He said, she said. It's the War of the Roses,
right.
Mr. and Mrs. Rose having a battle.
Yeah. So spouses, I mean, the rules seem simple, but in the facts, in the way that they are played out, they can be more complicated. Children, also, again, it seems simple. It's if you don't leave a will, the people that it would inherit, if you have a spouse, or whether or not you don't have a spouse anymore, they've predeceased you, you leave children, they're going to inherit if they're your direct lineal descendant. So if they're a biological child. Mm-hmm. But there's other ways to become a child under the law. You can adopt someone and then they become your child. So if you've adopted someone, they are your child. But the flip side to that is they are no longer a child of their birth parent. So if somebody is adopted, they can inherit from their adopted parent, but they can't inherit from their birth parent. They don't want this double dipping thing.
Isn't that interesting?
Right.
Okay.
Unless the adoptive parent is the spouse of your birth parent. So if your stepdad, for instance, adopts you, you can still inherit from both.
Right.
And then speaking of stepchildren don't actually have a claim against their step parent. So again, they don't want this double dipping. A stepchild can inherit from their biological parents. They
being the courts, when you say they don't want this double dipping, who's they?
The lawmakers.
Okay.
It's
the writers of the law.
Yeah, it's a policy decision, right? We don't want people to have any more benefit than others. We want it to be fair. So, if I had two biological parents and then I had two step parents, there's no reason why I should have a claim against four people's estates.
Right.
Which, can again get muddier if there's adoptions in there.
Which, if I'm the natural born child of Mr. and Mrs., I only can inherit once, kind of thing, right, from the total family estate.
Well, it gets more complicated than that. I'll talk about a case, for example. It's an Alberta case, but the rules are the same. It's called Peter's Estate. And the two parents were married for 43 years, mm-hmm, and they had 5 kids. One was the wife's natural born son.
From an earlier relationship?
No, from the husband and wife.
All right.
There were 4 daughters who were the father's daughters only. So they weren't children of the wife. So the father died first, and the 4 daughters and the son all agreed that the wife should get the entire inheritance. So they agreed to that. They agreed to let their father's money go to their stepmom. But then when their stepmom died, they argued that the estate should be split 5 ways. But unfortunately, there's only one biological child there. The 4 stepdaughters had no right to the stepmom's estate. And so the one son inherited the entire estate, and the 4 daughters were cut out. Because they weren't children under the law. They had the right to inherit from their fathers, which they had foregone in favor of their stepmom.
Wow.
Right. So it can seem a little unfair, but...
seem?
But they had...
Brutally. I mean, here are these 4 girls doing the right thing, but by the stepmom and saying, listen, Dad loved you, cared about you, so we're not going to insist on our share of the wealth and the inheritance now. We'll let everything fall to you until your death, so that you can preserve your style in the manner to which you've been living.
And what should have happened there then is that the stepmom, should have made a will, or they should have arranged for her to make a plan so that inheritance would be set out.
Right.
Because she could have chosen to adopt them, or she could have chosen to leave them an equal share in her estate.
So she could have said, I'm going to divide the estate into 5 equal shares, mm-hmm, for my son and my 4 stepdaughters.
Exactly. If she had a will, then it would have been fair. But because maybe they didn't get advice when they decided to just let her have the father's estate, they didn't think that far down the road, legally speaking, because there was no will, it goes to the biological children.
Unreal.
So it seems straightforward.
Now, isn't there somewhere a judge, or somewhere there's a process within the courts that would allow these four girls to call out unjust, unfair. We did the right thing earlier on. Somebody should be looking after us now.
Well, unfortunately, they did bring this to court, and the court said the law is quite clear. In an estate inheritance scenario, it's the biological children that inherit.
Right.
You had the right to inherit from your father, and you gave up that right. Probably they gave up that right without getting proper advice, because usually you've got the leverage there, right? That's when you're talking about giving up a right, you usually have an opportunity to ask for something in exchange. So that would have been the time to have the conversation about.
So they got bad legal advice,
or
one assumes,
or they didn't get any. Who knows? But sometimes if you don't plan ahead, then the law is applied unfairly. But from a policy point of view, looking at the population as a whole, it's meant to be fair. It's meant to not let people inherit from multiple parents. And but if they give up the right against their biological parent, then they don't have a right against their step parent.
I'm still trying to gather my jaw up because it is dropped in disbelief that these four women, stepdaughters of, would be, and somebody shrugs their shoulders and says, well, that's the law, and too bad, girls. You didn't do the right thing. You did the right thing relative to your stepmom. Mm-hmm. You didn't do the right thing relative to protecting your own interests.
Right. And that's not to say they couldn't come to an agreement with their stepbrother.
Yeah. Right. Okay. Listen, we need to take a break as we are in conversation with Nancy Ling from FH&P. I need to take a moment to take a breath to somehow put into context the challenge of what has happened to these young women. And I'm sure there's a few other stories like that somewhere down the road. But in that one very instance, there's a hard lesson to be learned. Back with Nancy Ling right after this. So we're in conversation on this Tuesday, this Law Talk Tuesday, conversation about the law with Nancy Ling from FH&P. And if there's anything I've discovered in the last 5 or 6 minutes of conversation, is that the law is unforgiving, that it is a hard taskmaster, that the idea of fairness only exists if the individual protects themselves, or only if the individual puts in place the paper, or has the foresight to look out and think of the various things that may happen. It's not easy.
You know what? It's about understanding the law and understanding your rights, because our government, our lawmakers, they make laws to try to apply to everyone, right? They're looking at for example, lowest common denominator. They're looking at the law that is going to be the fair to the largest group of people. And so there's a few outliers that this law is maybe not going to apply or affect the same way as others. And we do our best, and we adapt our laws as society adapts, and sometimes the law is a little slow to adapt. But as I've mentioned, this particular definition of child, that stepchildren are not a child, has actually survived a couple of constitutional challenges. A couple of times stepchildren have said that this is discrimination based on family status.
Yeah, no kidding.
And they've failed because the courts have found that stepchildren in society as a whole do not suffer any disadvantage or prejudice or anything. They do have equal rights of children. It's just against their own biological parents and not against their step parents. And there are options to remedy that if it should be, such as adoption, or as, leaving an estate plan that provides for these stepchildren.
But you have to have foresight. You have to be smart. You have to consult and talk with a lawyer. And sometimes, for a whole lot of people, these elements aren't readily in play,
right,
in however their brain is wired, or however their internal sense of what's right and wrong comes to function. I still have to come back to these four young women or women.
But it's
the
same.
They did the right thing. They thought first, not of themselves, and saying, well, we better make sure that we got paper that gets our share. They immediately said, our father loved you. And so we're not going to hack a whack off we're going to let you continue to live in the style to which you've become accustomed.
Mm-hmm.
we're good women. We care about you too.
And it's possible, on the flip side of that, think about it, they might have a biological mother somewhere that they're going to inherit from.
Yeah.
So,
might.
Right? We don't know about that. But it's also, people think about this all the time in the context of spouses. People are always concerned about protecting their rights as a spouse or protecting their rights from a spouse. People are always aware of that. They just don't always think about children in the same manner, right? Protecting your rights as a stepchild, or protecting the rights of your biological children. Like, for example, if you've got think of the other parent, right? If you've got 4 biological children, and you want to make sure your estate goes to your children, you don't want your new girlfriend's kids to take a share, it applies fairly in that circumstance.
Yeah.
So it's fact specific, and it can be unfair in very specific circumstances, but that's not the intention of the law.
And you just brought that case in point to drive me crazy.
to show that it's worth paying attention to, that people don't always think about children the same way that they think about, spouses when they're doing their estate plan, the importance of defining what the relationship is. But it is important.
So are there other people who are at play in a relationship? Are there other, styles of offspring?
Certainly.
Okay.
Well,
take us there.
We know that there's assisted reproduction these days,
right,
which throws an added curveball.
Does it really?
Of course, because there's the possibility under the new Family Law Act to have multiple parents. If you use surrogates or if you use donors, it's possible to have an agreement with them that they will be a parent or that they will not be. So for a same-sex male couple, for instance, they might use a woman, and then they want some of their genetics in the child. The woman is the biological mother, so technically she could be the mother or she could give up that right, and the 2 fathers could be the parents. So it's a little more clear to people that they need to have an agreement about what each person's role is.
I was just going to say, obviously, at some point in time, if you're entering into that kind of an agreement, you would have a legal arrangement.
Yeah.
You just automatically would wrap your brain around, okay, how's this going to work? How do we define it legally? Who do we talk to? How do we put it down on paper? How do we protect everyone's interests?
Right. So, and hopefully people do. Then hopefully they're doing it formally, and it's not just, okay, you're going to be my donor.
Yeah.
But there's also the possibility of a child that's born after death, or even a child that's conceived after death. So we've actually drafted laws to deal with this now. If a spouse of a deceased person wants to use their reproductive material to have a child after that person is dead, they can, and that child will be legally considered a child of the deceased. They have to go through certain steps, but essentially if they let the executive...
Basically, you're anticipating, and those stories have actually been quite common recently, where males anticipating death because they have an incurable disease or have banked their sperm. With the idea that, okay, should my wife decide at some point in time that she still wants a child of ours, that my frozen sperm can now be thawed and used to impregnate her, and she has our children together, even though I'm long dead and gone.
Right. So if it's a concern, if it's necessary that the child be treated as a legal child of the deceased for some inheritance right, maybe he left a will leaving everything to his quote-unquote children, or maybe there's a division to be had with some children from another mother, for example. If the mother was a spouse of the deceased and has this material, she notifies the executor that she's going to have a child. As long as she does that within 6 months of the grant of probate, and as long as the child is born within 2 years of the death and survives for 5 days, that child will inherit as though he was alive, or he or she was alive when the father died.
You're driving me crazy this one. Because to me, what is the absolute difference here in that while I was alive and I made love with my wife and we created a child and birthed a babe, I'm now dead, but my sperm has been banked and it's been used to father yet another child or create yet another human being. Their rights should be the same.
Right. Practically speaking, it may not make a difference in most scenarios. Most scenarios, if it's, husband and wife and they have a will, they might have just left everything to their spouse, or the mother might not be concerned about whether this child is going to get a share of the funds because this child is going to be looked after anyways. But in these rare circumstances where maybe there's competition for a share of the estate with other children or something like that, maybe it makes sense to have this child declared a legal child. If there wasn't a will, or if there, as I said, if there was a will that left everything equally to quote unquote children.
Anybody else in play out there in the wings?
I think that's about it. But I mean, it's worth noting that a biological child will always inherit, and we've abolished these rules about legitimate or illegitimate children. So in the past, it was a little bit of an antiquated view that illegitimate children didn't have the right to inherit. And so that's gone.
Really?
So legitimate children can inherit. So you've got these circumstances now where someone dies and you could have kids coming out of the woodwork and making
And
a
all
claim.
it takes is a DNA test. To show that I have rights.
Yeah. Or on the flip side, there was another case, Perry and McCutcheon, where the person was a child as far as she was concerned on the birth certificate, things like that. Someone came forward with information that she wasn't actually the biological child. They did a DNA test, found out she wasn't a biological child, and she was disinherited.
My goodness.
So there's all sorts of lovely little curveballs that can come in with children that we don't always think about. A child is a child is a child, but it's not that clear cut.
Not in the eyes of the law. Clearly, as you just said, the word is cut and dried, and it's not nearly that cut and dried.
Right.
Take a break on this Tuesday morning law talk with Nancy Ling from FH&P. One of the more fascinating conversations we've had over the last little while, at least from my side. Well, not that I've fathered a bunch of children around there that are running around legitimately otherwise, but it's just fascinating to hear the various viewpoints, I guess, if you will, that can be taken within the context of law, particularly within the context of inheritance. We'll be back in a minute. Well, when Nancy Ling walked into our studio this morning, she said, I'm going to take you on a bit of a journey, Phil, because we've talked often about spouses and wills and inheritance. Haven't spent nearly enough time, or as much time as we might have or should have, on dealing with children and who constitutes a child or what constitutes a child. Are there any other kids out there in the woods? Is there any other context or is there any other piece of what I'm finding is an unbelievably convoluted puzzle?
I think we've covered them. We're talking about biological children, adopted children, they will inherit.
In vitro
assisted reproduction children, stepchildren will not inherit. But it's important also to remember that we're dealing specifically with Wills, Estate, Succession Act here. We're dealing with a person's right to inherit or a person's right to attack the will. Children have very different rights under Family Law Act and things like that. So if it's during a person's lifetime, a child has a right to support if they're a stepchild, or if, this other parent, even though they're not biological, stands in loco parentis. So if they stand in the role of a parent, the child has a right to child support. So there's lifetime rights versus rights after someone's died. That's different. And the same thing with spouses. If you have that 50-year relationship and then you split up 3 days before death, you're not a spouse with the right to make the claims under the estate provisions, but you are a spouse for the Family Law Act provisions. You still have remedies under the Family Law Act. Again, they just don't want you to double dip. So you can't go after your alimony and after the inheritance. You can't go after your child support and after the inheritance.
But as you've said, we had this huge angry confrontation. We've decided we're going to break up. And 3 days later, he kicks over with a heart attack, and he's dead at the curbside. If life had gone on by another a week, as per our habit from earlier before, we've done this before. We always have this sort of big fight, and he says, "I'm through with you, and I'm out of here." And a week later, he's saying, "Well, I didn't really mean that. Let's get back together. Can I come home?" And I'm dramatizing it, but to me, I know people who have lived much of their lives in that way.
Right.
And if you fell over dead at the wrong time, a terrible set of circumstances suddenly come to be.
Right.
If you had lived for another 5 days, and as per your habit, you'd moved back in or moved back home, brought your suitcase home and put it back under the bed one more time, is there a case then to prove that this is your habit, this is your style?
I don't think so. It might be worth having a show on this with one of our family lawyers, but separation is one of the triggering events under the Family Law Act that triggers a division of family property. So separation when one party has the intention to separate.
But 7 times previously, we've separated, and a week later he comes crawling back like the cockroach that he is. And he wants back into the house, and being the nice woman that I am, I've let him back in the house. 7 times we've done this. This was the 8th. Does not this establish a pattern?
You might argue that there wasn't actually an intention to separate, but like I said, we're straying into family.
I realize. Again, it's just to me the foibles of human beings and the ways that we treat each other and the things that we do. What is it that the evil that men do lives after the good is often interred with their bones. The good side of you nobody sees, and we forget about. Anyway. Sorry, I didn't mean to take you down the road where we were going to go. So listen, is there a, I don't know, in some cases it's pretty straightforward. Is there a checklist? Have you done this? Yep. Have you done this? Yep. Have you done this? Nope. Well, you better get this done.
Yeah.
This is a little more complex than that.
The best solution is to have an estate plan. And if you do that estate plan with an estate planning professional, they're going to be able to point out these red flags for you, right? Mm-hmm. When you're talking about your children, they're going to ask the question, are these all biological children? Have you given up any children for adoption? Have you adopted any children? Do you have any stored reproductive material? They're going to ask you those questions.
That's an interesting question. Do you have any stored reproductive material?
Exactly.
Yeah. Have you stored your eggs or have you stored your sperm?
Because you don't want to fall into the trap of sitting across a table from a 50-year-old woman and assuming that she's not going to have any more children. It's potential to use a surrogate. And, there's a potential there for more children. So if you're actually dealing with a trained estate planner, they're going to be able to recognize these issues for you and do an estate plan for you that avoids these traps of accidentally disinheriting someone that you have every intention of looking after.
What it really boils down to, Nancy Ling, is engage a lawyer and spend some time in conversation. And through the course of the conversation, hopefully your lawyer then gets a few other light bulbs that come on above their head based on some of the things that you say, which then leads to second and third level questions that ultimately get to where you might never have been if it wasn't for those questions. Yeah,
we've said it before. Think about who your family is and who you want your family to be defined as, because the law might not define your family the same way that you do.
Where do people find you?
FH&P Lawyers. My direct line is 250-448-0527.
I'm looking at it right now, 448-0527. Nancy Ling always answers her phone and can be found amongst the excellent family of lawyers that are found at FH&P. Best thing to do is go to Google. Who doesn't these days? And type in FH&P Kelowna. It will immediately get you where you want to go. And right there under the drop-down menu, Our Lawyers is where you will find Nancy Ling. And if any of this has sparked any level of curiosity or in any of you a desire for further conversation and consultation, she'd be more than happy to talk with you, I'm sure. Thanks for being here.
Thanks for having me.
This has been fun. I would never have guessed when you walked in the door of my studio this morning and said, I want to talk about children and inheritance, wills and estates, that it would be quite as involved as it is.